Your Honor, I've been primarily working through my interpreter.
The attorney representing Mr. Huang tells a casually dressed judge on September 21st, 2010. The attorney quickly adds that
he seems to understand and speak English very well.
Did she just say that he seems to understand English very well? Does the attorney not know the client well? Does she know the client at all? No one seemed surprised. The judge, the opposing counsel, or even the client himself. Just me. What if the attorney makes a mistake because she doesn't know the client well? From the beginning of the hearing, what I felt was the attorney's indifference to the client, and what I feared was ineffective assistance of counsel. Then I asked myself, what happens to a client who is afforded an unfavorable decision because of attorney's incompetence or mistake? So I decided to do some research to find out, and my research began. Perhaps one of the most well-known cases on the issue of ineffective assistance of counsel is Strickland v. Washington. And the most recent Supreme Court case is Padilla v. Kentucky. But neither Strickland or Padilla is precisely on point, because they are both criminal cases, and deportation hearings are civil. Further research pointed to a number of recent cases on point, and they are Lozada, Compean 1, and Compean 2. In matter of Lozada, the Board of Immigration Appeals established the requirements for a motion based on a claim of ineffective assistance of counsel, which are known as the Lozada factors. First, a motion should be supported by an affidavit. Second, the former counsel must be informed of the allegation and allowed the opportunity to respond. Third, whether a complaint has been filed with appropriate authorities when there is a violation of ethical or legal responsibilities. The Lozada factors have been well established from 1998 until the Compean 1 decision in January of 2009 by the former Attorney General Michael Mukasey. In Compean 1, Mukasey held, among other things, that there is no Fifth Amendment right to effective assistance of counsel in removal proceedings, and that removal proceedings should be litigated while ensuring fairness, accuracy, expeditiousness, and finality, and that the board may reopen proceedings in the extraordinary cases, seemingly setting the bar higher. In addition, Compean 1 adopted a new administrative framework for a claim of ineffective assistance of counsel, but a closer look into Compean 1 seems unnecessary at this point because the current Attorney General, Eric Holder, vacated Compean 1 in June 2009. In his interim decision, Compean 2, the Attorney General vacated Compean 1 in its entirety and called for an administrative process for reforming the Lozada framework. Therefore, we're back to the Lozada factors when considering a claim of ineffective assistance of counsel until such new framework arrives. It's very important to ensure that immigrants have the due process of law because the implications and consequences are so grave to the immigrants and their families. Having done my research, I wanted to meet someone who had first-hand experience with ineffective assistance of counsel. Meet John Kim. He's 28 years old, a software engineer who graduated from the University of North Carolina in 2006. He married an undocumented immigrant, and they are expecting their first baby the day before John's foreign passport expires. With his passport expiring in February of 2011, John filed a perm application, ETA Form 9089, in March of 2010 so that he could apply for a change of status to that of a permanent resident before his passport expires. While filling out the perm application, John's attorney advised him to indicate that a foreign language is required to perform the job duties. Without hesitation, John followed his attorney's advice and checked off yes. The attorney's rationale for checking this off was that doing so would keep away the Department of Homeland Security auditors. Well, unfortunately, John's application was selected for an audit, and John later found out that his attorney's advice was absolutely incorrect. It turns out that checking the yes box on the perm application pretty much guarantees an audit. After the audit notice, John withdrew his original application and filed a new application in September of 2010, which meant that he had just wasted 6 months. A 6-month delay means that John might not be able to change his status before his foreign passport expires, which means that he has to go back to his home country. Currently, it looks unlikely that he'll be able to spend more than a day with his newborn, scheduled to be born on February the 11th, 2011, because his passport expires on February the 12th, 2011. My interview with John Kim made me think, is there any way that John can lawfully stay in the US to enjoy freedom, liberty, and spend time with his newborn and family? Looking through the federal immigration law over and over didn't offer a solution. But an unexpected source offered a potential solution to John Kim and his family. John Kim is married to an undocumented immigrant who graduated from high school and college in the United States, who has continuously resided for the last 12 years in the United States, and who is only 24 years old. The answer? The Development, Relief, and Education for Alien Minors Act, also known as the DREAM Act.